Hello, everyone, and welcome to Advancing Your Practice, Persuasion, Impasse Management, Unpacked, Part 2. Impasse Management, Emotional Invitations. My name is Taisha Preston, and I am the Administrative Assistant for SCMA. This event is in meeting format, which means you can hear and see us, and we can hear and see you. So we ask that you stay muted throughout the entire workshop. If you are requiring MCLE credit and or MC3 credit for this workshop, please make sure that the name that appears on your Zoom account is the name that matches your state bar. If you did not provide us with your state bar number, please send me a chat or email us at info@scmediation.org. Lastly, this event is being recorded. You will receive a link to all the workshops from the conference along with the certificate of attendance for those workshops that qualify for MCLE and MC3 in the next 7 to 10 business days. If you have any questions regarding the event, please feel free to send me a chat. I would now like to introduce to you Elisa Brodkowitz of Lightning Law, who is our Platinum Workshop sponsor.
Hi, everyone. I'm going to share my screen for a moment here. Hopefully you can see this. Just a little picture of Lightning Law. So my name is Elisa Brodkowitz. I've been an attorney for 20 years and doing aviation work representing victims of plane crashes. So in that capacity, I found myself flying all over the world, and in 2018, started doing what I called paperless depositions and paperless mediations, which led to me deciding to start a tech company, legal tech. And here we are in 2021, where all the ideas about where we mediate and how we mediate has been challenged and changed. So we are coming out with our software in January of this year, and our market entry is for mediators. So before I tell you a little bit about the features, I just want to tell you about the mission of our company. So we really believe that in the past couple decades, we've all started to think about court or dispute resolution as a place. We go to the mediator's conference room or we go to the courthouse. And we believe that court and dispute resolution is a service, and that it harkens back to the time of Abraham Lincoln, when he rode as a Supreme Court justice on his horse, Old Tom, for half the year, bringing court and a judge and another attorney to inns and taverns all across the 8th Circuit. So that's the idea, that court is a service. We're all about access to justice. And as long as we're profitable, we provide our software for free to legal nonprofits. So a little bit about the mediation software. It's all online, it's all virtual, and it's meant to really emulate as much as possible what we're doing online as in person. So you can knock on a room before you enter it as a mediator. You're given, you can track your offers and demand. We track it for you, and we crunch the numbers to show you the deltas. For lawyers, we give lawyers tools to show their clients what this means in today's dollars if you were to settle the case. So you build in the lien and you build in all the other documents. It is a integration of video on one side of your screen and documents on the other. It's not a share screen, which we found that litigants didn't really want to do. And it's not a send file. The other party doesn't download your documents. So it is what we call show and tell, for lack of a better word. So that's Lightning Law. We're giving folks involved in SCMA an opportunity to beta test our product in December. So if that sounds interesting to you, you get to use it for free. Give us your feedback. Just send me an email at elisa@lightning.law. And with that, I will turn it over to Harold and Peter and Michael and Jim. And thank you all for your time.
First, I would like to say thank you, Elisa, and thank you to Lightning Law for your continued support. And at this time, we will actually like to welcome Jim Cameron.
Good afternoon, everyone, and thank you, Taisha, and thank you, Elisa, and to your company, Lightning Law, for your sponsorship of today's program. My name is Jim Cameron. I'm the co-chair of SCMA's Attorney Outreach Committee and a past member of SCMA's Board of Directors. It's my pleasure to welcome you to this afternoon's program. This is in fact part 2 of a 2-part mini-series presented by SCMA Prime Productions. The series is called Advancing Your Practice Persuasion, Impasse Management Unpacked. That's a very Hollywood sounding title. This morning we got the first episode, which was Emotional Interventions. And as one of the panelists, Bill Eddy, was describing, it's about the right side of the brain where the emotional energy resides. And he and Deborah Dupre and Harold Coleman Jr., who's with us this afternoon, did an absolutely great job in explaining how important it is to, get through the emotional stuff in order to get to the rational problem solving. But this afternoon's concluding episode of our mini series is the analytical tools and techniques part, and that's this left brain thing. And we're very pleased to have the aforementioned esteemed Harold Coleman Jr., as well as Peter Silverman, and a special guest not announced previously named Michael Hawash. And I have the honor of introducing each of them to you and then turning the program over to them. Harold Coleman Jr. Will be the moderator, and he's certainly no stranger to our conferences. Quite blissfully, he's not a stranger. He's become quite a pillar of our annual conference the past 5 years. He's the Senior Vice President for Mediation at the American Arbitration Association and its technology innovation, AAAmediation.org. He's based in Southern California. Harold is the guru of mediation for AAA, and we're always very blessed to have him and his wisdom join us. He began running what we used to call the advanced track back in 2017, and he's been a co-collaborator on our annual conferences since then. He's been a law and dispute resolution practitioner for the past 35 years. His experience has included extensive complex litigation, mediation, conciliation, arbitration, and ADR teaching. Notably, he was the distinguished recipient of last year's SCMA Cloak Millen Peacemaker of the Year Award. Harold, you're late. Congratulations on that. A very well-deserved award. And, Lee J is your noble successor this year. You guys have continued a wonderful tradition of leaders in our community. Harold's passion is promoting and modeling purposeful and ethical advanced dispute resolution practices that address the emotional as well as the analytical dimensions of impasse management in mediated problem solving. Harold will explain why he calls it impasse management. I don't want to steal his punchline. Harold, we thank you for organizing both programs today, and we're now looking forward to learning about the left brain stuff. So to our next panelist, Peter Silverman, and we have a national panel here today. Peter comes to us from Toledo, Ohio, where he's a partner at Shoemaker, Loop and Kendrick. He's focused his career on commercial and business litigation, with particular focus on franchising and distribution, intellectual property, securities, sports, and antitrust disputes. He began his ADR career first as an arbitrator in 1986, and then his work as a mediator in 1990. He's a longtime member of AAA's large complex case arbitration program, as well as the conflict prevention and resolution panel of distinguished neutrals. And he's also on the board of the Ohio chapter of the National Academy of Distinguished Neutrals. Notably, he is also the sole United States arbitrator on the arbitration panel of the European Union-based International Distribution Institute, which offers expedited arbitration for international distribution and franchising disputes. He's a founding trustee of the Early Dispute Resolution Institute and drafted himself the early dispute resolution protocols to which we often refer. He's been also very active in civic matters. He served on the Toledo City Council, the Toledo School Board, and, if you please, the Ohio Casino Commission. He teaches seminars on ADR nationwide and writes extensively in our field. Peter, it's my pleasure to welcome you today.
Thank you.
And now we have our surprise guest, not listed in your program materials, and we didn't even have his photo up, most ashamedly. His name is Michael Hawash, and he comes to us from Houston, where he has his own ADR firm. Peter Silverman himself describes Michael as a decision tree maven. And so Michael will focus his remarks today on how you build and use decision trees as a mediator. He's an experienced commercial litigator who now serves as mediator, arbitrator, and early dispute resolution professional. Like Peter, he serves on AAA's arbitration panel, as well as the JAMS arbitration panel, and he's on the Texas Department of Insurance's mediation panel. He's a member of the board of the EDR Institute and serves on Texas's Mediator Credentialing Association. Jack Getz, if you're with us, Texas has a mediation credentialing association. So perhaps you and MC3 can liaise through Michael to see what they're up to. Michael, it is our pleasure to have you here today. Thank you so much for joining us. It's my pleasure to turn the program over to Harold, who will be the moderator for part 2, Analytical Tools and Techniques. Harold, I'm happy to give you the floor.
Great. Thank you so much, Jim. And I can tell you, you did a fabulous job with that introduction. You cut off about 3 minutes of what I would have otherwise gone through. I will say this, though, in terms of impasse management, why that term, some of the foundation we laid this morning, colleagues, is that a great fear of many mediators is, well, I'm afraid that at mediation, we're going to run across impasse. I want to make sure that we avoid impasse. And then again, newsflash, there's no such thing as impasse avoidance. Parties come to mediation at a state of impasse. And therefore, interventions for managing that impasse exist, we believe, in 2 dimensions. One, the emotional dimension, meaning the first order of business is to stabilize the patient before we can do surgery. So we have to deal with the emotional needs and the negative emotions that are producing, in most cases, entrenchment in impasse. And then, and only then, once we've stabilized the patient, can we then move into the analytical dimensions, where you get into decision trees and bracketing and BATNAs and these kinds of things that appeal to the rational center of the brain. And that's what we are going to look at now. So hence, impasse is about management. It is not about avoidance per se. That train has already left the station. So here's what's going to happen. In the space of the next 40 minutes, my good friends and colleagues at the nonprofit Early Dispute Resolution Institute are going to walk us through, they're going to have a live demonstration on building what they believe might be the ultimate analytical tool to be used to intervene in impasse. And that has to do with the risk assessment tool of decision trees, how to build one, how to interpret the outcomes, and then how to go ahead and convey that information in a way decision makers can receive it and hopefully make informed determinations as to what's in their best interest. Pull up, if you would, real quick, Pete, just the overview of last year. We had my friends from the Early Dispute Resolution Institute address SDMA, and they outlined this 30-day protocol that virtually any case can be resolved in 30 days with these 4 EDR steps. And I guess we're still waiting for the visual on it, but let me outline for you what they are. The first
Oh,
is,
Harold, Michael's computer crashed. He's now back on and he's trying
Yeah,
to
I'm
get the
getting
slide
back
up.
on and starting
Oh,
the
okay.
PowerPoint, Harold, but
No
you
So
guys,
keep on
go
going and we'll
that's all
try to
right.
get
The
the
show
slide
will
up.
continue to go on.
All
So
right.
the very first step is the initial dispute assessment. And that occurs during the first 6 days after a matter is submitted to EDR. And then after that, there is a meaningful information exchange, followed by, and this is where we get to the crux of it today, risk assessment, okay, a risk valuation that is done objectively so parties can then determine what is in their best interest, which then will lead to step 4 of the overall matrix, which is final resolution. And whether that be a mediated resolution or whether it would involve E&E, early neutral evaluation on the part of an intervener, such as a mediator or a neutral evaluator, or perhaps even binding arbitration. But the idea here is that if we have applied the appropriate emotional interventions so that now parties can get into the rational center of the brain, they are much more apt to embrace these analytical tools and techniques to help them arrive at not an emotional decision, but an informed, objective decision as to what is in their best interest. So it's going to be easy moderation from this point forward because I'm going to zip it and get out of the way. It's like a mediation when things are going well and the parties are engaged and they are really, really making significant progress. We got to have the discipline to just zip it and let them do their thing. And Pete and Michael, I'm going to do just that now. So
Keisha, can I
thank
get you to enable my screen share so I can start our PowerPoint, please? Unfortunately, I had a crash.
And while, you know, Michael, while that is occurring, okay, great.
Hold on. Yeah.
Pete, while Michael is getting the technology in line, would you share just some of the successes that you have realized from actually mediating cases in 30 days from start to finish?
So,
protocols?
right. So we weren't going to present on early dispute resolution today. We did it last year. And this risk analysis is dense stuff. We wanted to have the time. But we now have a pilot project up in Houston. We have 15 trained neutrals working, doing that, and it's very exciting. Michael and I have been practicing this now for probably a year and a half, and the early dispute resolution works remarkably well. We have protocols, and it's working very well. And Michael, while what do you want us just to proceed, Michael, without the slides for a bit? You're on mute now. Michael, you're on mute.
My screen is freezing and I'm unable to share the screen on the PowerPoint. So please just go ahead and I'll try to get it working.
All right. Let me start by giving you an overview. And everybody says you should be able to do this without PowerPoints, so this will be good. Part of it will need the screen for Michael's building a decision tree. The agenda here is, first, we're going to give an overview. Second, we're going to show you how to build a tree. Michael's going to do a live demonstration. And the third is we're going to give you Risk Analysis 101. These are very cool tools. You don't need to use them in early dispute resolution. Every neutral can. And I hope we're very excited to have the opportunity to present on this. And normally it's about 4 hours of our 2-day training, but we're going to try and condense it now into 37 minutes. So let's start with the overview. And I want to give you a broad picture here of what we're going to be looking at. you've got all kinds of resources in your materials. So if some of this is confusing or too dense, you will be able to look back at your materials. So let's start with the overview, and I'm going to take you back in time. Let's assume that in 1776, let's imagine that you teleport. I feel after those introductions, all I kept on thinking was, we're Dr. Spock. So this is apt. Let's imagine you teleport a lawyer, doctor, scientist, and engineer from 1776 to the present. And they land in California in 2021, and they want to resume their professions. What would happen? Well, let's take a look at the developments that the doctor, the scientist, and the engineer have missed in the last 245 years. So here's the first 100 years of development in their field. Now let's look, that takes us up to 1869. Let's look at the next 50 years. And these are all the developments in their field for the next 50 years. Then let's look to the next 75 years. That brings us up to the present. And at the bottom of this list, I've just put all the new companies that have started in the last 25, 30 years that are now the largest companies in the world. So if the doctor, the scientist, and the engineer said, well, I'm ready to start my practice, they would be shocked. They would know nothing. They would be completely bewildered and perplexed, and they would have to go back to school for years to be able to practice. Now, let's look at what happens with the lawyer. So this is progress in dispute resolution in the law. In 1789, there was a mishmash of procedures in state and federal courts. After about 150 years, we got the federal, the rules of civil procedure. Then in about 43 years after that, we moved to modern pleading rules, and law and equity had been unified. Then about 1990, ADR started, mediation and collaborative law. And so those are the developments in law. So law is the tortoise, and all other fields are the hare. The lawyer who came from 1776, or as Lisa said, Abraham Lincoln, pretty much recognized what's going on. Probably take a couple weeks, but they'd be ready to go. So we're trying to bring you the latest tools in risk analysis and bias thinking to help bring lawyers and neutrals into the hare world. So with that, what we're going to do is Michael's going to be teaching you about decision trees. If any of you are interested in further training, you can go to the Early Dispute Resolution Institute. We're also working on joint training with the AAA. But today we're going to try and open your eyes to these tools and how you can use them. And again, we've got a book by Marjorie Aaron in your materials that's awesome. Probably takes a good 10 to 15 hours to work through, but it will give you much more in-depth experience in this. Michael, take it away.
All right. Well, I apologize, everyone, for the technical difficulties we're having. I think I may have had too many windows open, and it was causing my my computer to crash. But hopefully we're through that now. I am going to have to switch to another website in a minute. And if we do have another crash, then please bear with me. I'm going to log right back on. So just hold on. If any of you do have an additional screen or an additional laptop, something separate from the screen that you're looking at with Zoom, then I'd like you to go to a website called silverdecisions.pl. That website again, silverdecisions.pl. We're going to be talking about it. And as I teach you how to do decision trees, if you're on that website, it would help if you could sit there and do it along with me. But if you've only got one screen, just stick on this one screen and watch me do it. Decision trees have literally transformed my mediation practice. Last week I had 4 mediations. I used decision trees in 3 of them. And probably the only reason I didn't use a decision tree in the last one is we reached a point early where the parties didn't even exchange offers, and we had to abate the proceedings for a later date. But the great thing what decision trees do is they allow you to show the parties how different outcomes and different risks within the case impact the adjusted risk value of the case. And what is that adjusted risk value? Really what that is, for a mediator at least, it's really a settlement value or range of where settlement, a reasonable settlement value should occur. Before I get into how to build a decision tree, I just want to do a quick disclaimer, and Peter mentioned this earlier on. Peter and I teach with our colleague, Ann Jordan, we teach 1 to 2 day classes on early dispute resolution and risk analysis. And when we teach those classes, the module on decision trees is generally about 2 to 3 hours. And I've got about 15 minutes today. So it's going to be challenging. I'm not going to be able to teach you how to build a decision tree adequately in that time, but I do have more modest and a worthwhile goal. And that is, if I can introduce you to decision trees, I might be able to whet your appetite a little bit so you go out and learn how to do them. The technology is freely available on the internet. I'm going to give you an idea of how they're used. And if you just kind of get into this website that I'm going to take you to, silverdecisions.pl, and monkey around with it with just a little bit, you will learn how to do them. All right, so let's get into to actually how to do it. The easiest way is just to go over a hypothetical and assume a hypothetical case. All right, so imagine that you're mediating just a simple car accident case. All right, there's no attorney's fees involved as far as the plaintiff is concerned. The plaintiff's attorney is on a contingency fee. You go into an initial caucus with the plaintiff and you start asking them some facts about their case. And plaintiff's attorneys, what you ask them, what's your chance of winning? Oh, I think I'm going to win, more likely than not. Well, give me a percentage. What does that actually mean, more likely than not? I think I'm going to have a 75% chance of winning. Okay. Well, if you win, what kind of damages do you think you're going to be awarded? Well, I think that I'm going to get, my best day is $200,000. My worst day, $25,000. And then the most likely range of damage is 100,000. Now, what you want to do is you want to encourage the plaintiff's attorney to give you percentages for those as well. So let's assume that he gives you a 25% on the high and the low, and then a 50% on the most likely. All right. Now, you're armed with that information. Here's how you build a decision tree. Now, this is where we could have technical difficulties. So I'm going to stop sharing my PowerPoint here and try to go to a website. So once again, if I drop off for some reason, just bear with me and I'll get right back on. All right, we are having some problems, but all right, are you guys able to see the website?
Yes.
Okay, good. All right, so this is silverdecisions.pl. This is a freely available website where you can make decision trees. And so you just go to the main page and hit run. And it'll bring you to this page. And this is where you get to build your own decision tree. Now, you're going to think it's complicated. It's not. I'm a guy who I can't set up a television. I couldn't put my kid's Xbox together. I am not technically inclined at all. Yet I've been able to figure this out. So if I can figure this out, anybody can do it. All right. So here's what we do. You take your mouse and you just right click and you add what's called a chance node. Now a chance node, all that does is that simply represents your case. All right. think of a case or a chance. The circle is a circle of possibilities, a circle of things that might happen. I'm going to make it a little bit bigger for your screens here. And this can all be done on the layout if you're trying to do this with people in a mediation. Okay, now from our chance notes, so this is a case, all right? This is your car accident case, the circle of possibilities. Well, what can happen? Well, the two most simple things that can happen if you go to trial is you can win and you can lose, all right? If you lose, that's terminal to your case. That means it's over. If you win, that's another chance, because now you have to, when you win the case, you win the case on liability. You still have to have damages. So there's different decisions that need to be made after that, okay? If you win on liability, you go to your circle of possibilities again, right click, and then you can add another terminal node. And then remember, when we talked to the plaintiff's attorney, we asked him for the range of damages, the high, the low, and the most likely. And so what we're going to do is we're going to add 3 terminal nodes. All right, now let's,
for the audience, that the one on top is the loss that ends with 0, and Michael's working on the one on the bottom, which is what happens if the plaintiff wins.
right. So what I'm going to do now is, now that we've kind of created the chart that shows the various decisions that could occur in this very simple car accident case, we're going to go in and populate the data, and I'm going to show you just how easy that is. So the first one I created was this, the terminal node, which is if you lose the case. So I go over there and then I just left click on that arrow, and it brings up this little menu down here. And so I can label it if I want. I can say, okay, this is a lose. If I lose the case, right? The payoff is 0. And what I did, if you remember, when I asked the plaintiff's attorney, what was your chance you're going to win? He said 75%. Well, that means you've got a 25% chance of losing. So you put 0.25. And this, if you see now, the tree's automatically populated. So here, the lose, the 25% chance of losing, you get $0, but then a 75% chance of winning. And so I go back down. Once again, I left click on that. I can put win, label it. And this is, it's good to label them because when you're showing them to counsel and the parties, it's easier for you to explain what is being shown by the tree. All right. So now we go to the next. So now they've won the trial. So we go to our circle of possibilities, and now we're going to populate the various damages that the plaintiff's attorney gave me. So he said his best day. So we can go up here, and all you do is you left click on the arrow, and then it brings up this menu on the side, and we can put in best day. And what he said was $200,000. And let me give you a little practice point here. Sometimes you might want to feel to put in a comma. It won't, this program won't recognize commas. And so you see how you get these 2 little exclamation point, red exclamation points. That's your indicator that you've done something wrong. You've entered data wrong, or there's something missing. So in this case, what I did is I put a comma in, and you can't put in a comma. So if I put in, so that makes the exclamation points go away. And when we spoke to the plaintiff's attorney, he told us he had a 25% chance.
Michael, you still have the comma in there.
No, it comes up on it. It'll put the commas in there for you. You just can't put it on the variables on the side. Okay. So the program will put in the commas. You just can't put them in on when you're entering the variables. All right. And so remember, then we had the worst day. So we put in, we go in here, our worst day. Maybe the, he understands the jury may not give some pain and suffering damages, whatever it is. And he realizes that $25,000 would probably be the lowest he would get with a win. And he said that was a 25% chance. We put in 0.25. And then what we do is we have the mid-range damages. So once again, we just click on the arrow. We can put in And what I like to do when I'm dealing with parties is I like to say most likely. Sometimes when I label these, I'll label them the BATNA, the WATNA, and the LATNA, the worst alternative, best alternative, and likely alternative. But if you put in best day, worst day, and most likely, particularly if you're showing them to the clients, they tend to understand that a little bit better. And on this, the plaintiff's attorney had said that it was $100,000 and the percentage likelihood was 50%. So as soon as I enter that, this is when the magic happens. And this is what makes this program so wonderful. It populates the entire table, right? All you've done is create the decision points and then put in the data. And then if you've done it right, it'll populate it. And you have to, it's a little bit counterintuitive because you've got to read it from right to left. But then if you look over here, this gives the risk-adjusted value of the case based on the information that you've received from the plaintiff's attorney. So this is using the party's own analysis. You can come up with a risk-adjusted value of what a reasonable settlement value might be using these assumptions. And then as the mediation progresses, let's say that the defense attorney, comes up and says, look, we've got this statement from a witness that says your client, rolled through a stop sign. Does that modify, would that modify your view of the case? And maybe the defense attorney goes, well, you know what, now that it's given that witness statement, I'm no longer 75% sure that we're going to win this case. Now I think it's more like 50%. So you can go in here, change that number, change that to 50. Oops, excuse me there. And bam, it populates a new decision tree for you with a new risk-adjusted value of the case that is based on what the defendant is saying, what different data, different variables. And likewise, you can adjust the damages numbers. You can adjust all of this and to help you determine what a risk adjusted value of the case is. This is a simple decision tree. There are ones that you can make that are much more complicated. You can add in, for example, another decision node in order to handle dispositive claims. So let's say that in this incidence, there was a statute of limitations issue that the plaintiff would have to get past even to get to trial, or a motion for summary judgment or something of that nature. All you have to do is add another decision node.
Hey, Michael,
yes, sir.
before you do that, why don't you show them how future attorneys' fees affects this and how you can show to plaintiffs and defendants what the results would be if they add in the attorney's fees, and discuss with them your notion of the sweet spot.
Sure. So this is the plaintiff's decision tree, right? This is based on the information that the plaintiff has given you. And let's assume that you could go to the defendant and you can ask them the same as for their assumptions, and they may be the same, they may be different. But if you can generally get the parties to have some type of similar analysis of the case, when you do it for the defendant, the defendant, unlike the plaintiff attorney in this case, has attorney's fees because they're paying an attorney to defend them. So right here on the payoff, and if we were doing it for the defendant, we'd be using negative numbers, but in the interest of time, I'm just going to use positive numbers. And let's assume that the attorney's fees to take the case through trial are going to be $20,000. And so win or lose, the defendant's going to pay $20,000. Well, so when you do this very same decision tree, using the very same assumptions for the defense attorney, their risk-adjusted value is $73,000. In other words, higher
Michael, we're at 5:15, so probably a good time to turn it over.
Okay. Thank you for letting me talk. If you have any questions at all, my email address is michael@houstonmediation.com. I'd be happy to go through the silverdecisions.pl website with any of you on a Zoom call, show you how to do it, one-on-one instruction. Happy to help. Peter?
Okay, so decision trees are a subset of risk analysis. Now we'll look at other aspects in our risk analysis 101 segment. Let's start with another graphic way to present risk analysis to lawyers and their clients. So next slide.
I'm sorry, Peter, it's crashed again. I'm going to have to stop and reload.
Okay. So when we come back, what I'll show you is you can present this in graphical form also. And we'll be glad to send you copies of the graphs because sometimes it's easier to see. The foundation that we built this on was dealt with confidence in forecasting. So we have a survey up that probably close to 1,000 lawyers have taken now. We asked 3 questions. And if you want, you can put your answers in the chat as we go through this. First question was, you get a case in and you do the initial review, you call the other side, you've looked at a couple documents, you've talked to your client. How confident are you that you know where this case should resolve? That's question 1. And if you want, you can write down your answer to that. Then the next question, there it is. You call your client and say, hey, I got to see a couple of key emails, and there's one report that's referred to I want to see, and I'd like to talk to your quality control manager for 5 minutes to see his take on this. So after you do that short follow-up in the first couple of weeks, how much does your confidence grow in how this case will resolve? If you want, write down the answer, and if you want, you can send it into the chat. The third question is, assume now you go through full discovery and depositions and summary judgment motions and they're denied. How confident are you now that you know roughly where this case should resolve. So as I said, we've done it about 1,000 times, and the results are remarkably robust. And so the results are this, that after initial review, the average answer is 57%. After the short follow-up, it's 62%. And then if you go through the full discovery and full motions, it's 64%. So the punchline is, if you say to the client, well, I know now after 2 weeks, roughly where this was going to come out, and you can spend $250,000 to go through discovery and motions and everything else up to trial, and my confidence is going to go up 2%. Is that worth it to you? And the client will obviously say no. So once we realize that you've got this confidence in your forecasting, the question is, and this is what clients rely on. You know, a lawyer says, I think we've got a good case, a bad case, it's reasonably good, reasonably bad, whatever. That's all clients have to go on. And so risk analysis helps lawyers refine their forecasting. One common, and so what we try to do here is, how do we refine that? So the first is statistical thinking. We can't think well statistically. Our intuitions are off. And so I'm going to give you 2 problems. If you want, you can write down your answers in the chat if you want to show people whether you're right or wrong. The first deals with a type of issue that comes up in many cases, and that's independent claims. So here, assume that Patty has 2 claims. The first is she was fraudulently induced into entering the contract. Regardless, David has materially breached the contract. So she has 2 claims, fraudulent inducement, material breach. Don't worry about burdens of proof. With either of them, Patty's entitled to rescission if she wins. She has a 50% chance of prevailing on each claim. What are her chances of prevailing in the case and receiving a judgment of rescission? So I'm going to give you a few, I'll give you 10 to 15 seconds to think about this, and you can just give me an intuitive answer. And if you want, you can put it in the chat. All right, let's look at the correct answer. So the correct answer, most lawyers answer 50%, but it's not 50%. And here a pie chart will help show you how you think through independent claims. Imagine each quarter of this pie chart is an actual quarter, like 25 cents. And so that makes up 100, like percentages. So initially the 4 quarters are split apart. Now we say if you win on the first claim 50% of the time, so take 2 of those quarters and move them to put them together on the win side. So in here in the pie chart, there'd be 2 quarters put together. Then you've got 2 quarters left. And on those 2 quarters left, even if you lose, so these are where you've lost on the fraudulent inducement claim, but you still have 2 quarters left where you can win on the breach of contract for 50 cents, for 50%. So you take 50% of those 2 quarters and you move 1 to connect with the others. And you get a pie chart like this where you show 3 quarters chance of winning. For those mathematically inclined, it's 0.5 plus 0.5 times 0.5. Now let's take a look at the second problem. Frequently, cases have as sequential claims. So sequential claims are, for example, if you have a statute of limitations, you can win or you lose, and then you go to your total claim, which would be for breach. So here for this hypothetical, assume that Paul is suing for breach of contract and that Donna has raised the defense of statute of limitations. Paul has a 50% chance of prevailing over the statute of limitations defense. If he prevails, he has a 50% chance of prevailing on the breach of contract. what are his chances of winning the case? So if you want, you can put it in the chat, right? So he's got 50% on statute of limitations. And then if he prevails on that, he has a 50% chance of winning on breach of contract. And now we can go, Mitra nailed it, to the next slide. All right, he has a 25% chance of obtaining rescission, and it's 0.5 minus 0.5 times 0.5 equals 0.25. And somebody in the chat made a great suggestion to label these pie charts L or W, and I'm going to do that, and I'll give credit to whoever suggested that. This is the same chart. It's just that you're subtracting the 0.5 times 0.5. And when we're done, if you want to mess around with quarters, you'll get a recording of this. You'll see how that works. Our time is limited, so I'm going to have to go through these quickly. Oh, Susan Guthrie. Okay, Susan, you get copyright on this from here on forward. Now, depending on how well you follow the sequential, you follow decision trees, here's a decision tree that shows how you would work this. And what's good about this is decision trees force you to think through these issues so you don't make statistical errors. So here you've got a chance node at the start. You can win on the statute of limitations or lose. If you lose, you're done. You go up to the second chance node, and you can either win on breach or lose on breach. And if we use $100,000 as damages to make it easy, you look back, it populates back to 25,000. So they have a 25% chance of winning. Lawyers regularly mess this up in their cases. And these are simple ways of showing them why they're way off. Regardless of how much the percentages of winning or losing, they're not thinking clearly statistically. So let's move on to biases. I've only got 5 minutes, so we're going to go through these quickly. But this is Kahneman and Tversky. And these are the 3 major biases that we think affect settlement: framing, confirmation bias, and overconfidence, and anchoring. Let's turn to framing. So framing is similar to what Michael was talking about. And normally when we do mediations, we get these sprawling mediation statements, in which sometimes it's like the parties are talking about 2 different cases. So that's how it's framed. If you can get the parties to do a risk analysis, you can get them to where cases boil down to a decision tree or risk analysis chart. That's a great way to frame the case. The next is anchoring. So usually we go to mediations and the plaintiff offers, demands $1 million and the defense offers $1. And then it goes to 990, 10,000, blah, blah, blah. And parties get anchored on these numbers. Here, what you can do is if you use this model and you make parties do discount by probability and fees, you get numbers that are very realistic that parties can get anchored to, and it's a much easier mediation. Let's turn to confirmation bias. So confirmation bias and overconfidence are the worst. And here, I use a 75% rule when I'm talking to parties or as a trial lawyer. I've tried cases for 40 years. I've lost a lot of cases that I should have won. So I know that there's no case that I'm going to tell my client I'm 100% chance of winning, unless it's a slam dunk. And so the rule of thumb, I think, as for a good case, it's no more than 75% likely, especially with juries. There's a 25% chance things won't go your way. So this forces parties to become reasonable. Next is the importance of WATNAs. Parties tend not to look at WATNAs. The decision tree or risk analysis forces you to do that and take into account. It's what's called a fat tail problem. Like in an operation, if you can die and it's only got a 90% chance, the doctor says, well, 1 out of 10 patients die. It forces you to think about the WATNA. The third is in our early dispute resolution protocols, we have parties exchange the risk analysis so clients get to see what the other party's thinking. And ultimately, the goal is to empower the client. So in mediation, it's often a battle. And Jim Cameron says, make sure we all understand WATNA, worst alternative to a negotiated agreement, which Michael said is your worst day. In mediation, one trouble I've always had as a mediator is I feel that we're just harping on parties to find somewhere in the middle. And it's not necessarily a principled discussion. Clients don't know, they're relying on their attorneys, and they don't feel they have any confidence. This forces lawyers to, one, refine their decision, their judgment, and two, to present the client the information in the way that we all use information in our day-to-day business and personal lives. Should I get the COVID vaccine? Should I take the bus or the train? What's the likelihood my plane will be delayed, and should I get an earlier one? We all know how to make those decisions in the face of uncertainty if we have a handle on it. This practice empowers clients. There are some resources, and you'll have this slide, and you can see the resources we have here. We include Marjorie Aaron's book, which we put in the papers, and some other things on decision analysis. If you look at my book at the bottom, it's got this chart that I've used. We have a much clearer chart now. We're also going to put up things at our EDR Institute. If you want more training, you can sign up there to find out when our next training is. And soon with Harold, we hope to be offering this to the entire AAA panel. With that, it's 5:30. I wish you all congratulations. This is the hair world, and we've got great tools. And I think these tools can help us all as neutrals. But the best thing about it is it really serves people. And this goes back to the first comments that Alyssa made, that we're about service and serving people and moving it out of this lawyer as lawyers know best and clients go along to where we really empower clients to make principled decisions. I wish we had time for questions, but we had a lot of material to present. You can send emails to any of us. And if you look at this again, you have questions, just reach out and let us know. Thank you very much.
Great. And Peter, if you would, the website, Early Dispute Resolution Institute website address is?
edrinstitute.org.
.org. Very good. Well, bravo. Thank you so very much. You talk about analytical tools. This has got to be the quintessential one that really breaks it down. Thank you for visiting with us here at SCMA 2 years in a row. We hope to have you back in the future for even deeper dives in this really important impasse management area. And with that, let me thank everyone and appreciate your participation. And let's see, I guess we'll go back to, is it Jim? Or just yield to you? Okay, thank you.
Just very quick thank you, Harold, Michael, Peter, we can all now give our left brains a nice rest, right? Take us back to the morning, please, when you're dealing with hard energy. It was really terrific, and thank you for the level of detail that you were able to work in a short period of time. We look forward to learning more. So my thanks to you all. Taisha, I guess we have a 10-15 minute break now, and then we go back to plenary. Yes,
correct. If you guys can all meet us again, I just want to say thank you for joining, and again, thank you everyone for your support. You can join us for the closing remarks at 2:45, and then the closing plenary. I can never say the word. Plenary. Is that correct? I always say it wrong, but yeah, I'll see you guys soon. Bye.
Bye-bye.